the big news of the day is the fact that the Supreme Court has handed down 2 disastrous decisions overturning student debt cancellation and allowing for discrimination against same-sex couples in the case of the graphic designer. We'll start here with the student debt one. The major story, though, that ties these cases together is that after oral arguments occurred in both cases, the plaintiffs standing their claims of harm were found to have been fabricated. Let me repeat that. The underlying harm in these cases, both of them, is false. On the federal student loan front, these are federal student loans, and yet the states were claiming that they had standing. Kagan went after that in her dissent in this case. There was a glimmer of hope at the start of the day because they had ruled there were 2 cases that one of them didn't have standing, but then in the second one they just took the opportunity to overturn Biden's student debt cancellation for 43 million borrowers. But part of the issue here is that when Biden introduced the student debt plan in late August, the forgiveness plan, the attorneys general from a bunch of Republican states immediately sued. And their case was hinged upon a claim that Missouri's higher education loan organization, known as the Missouri Higher Education Loan Authority, MOHELA for short, would be harmed because of the policy. And the Debt Collective and the Roosevelt Institute did a FOIA request, which they then shared with the New Republic. And there was an internal impact analysis from MOHELA back in, again, that Missouri Loan Authority back in May, which showed that they would make money, make $97 million annually after the student debt cancellation went into effect. So the standing in that case is fabricated. It wasn't harm. It was the freaking opposite. And so now these tens of millions of people are going to be prevented from getting their student debt relieved based on a case where the plaintiff isn't even being harmed. And it's just extra gross that they chose to rule and say, well, this other case doesn't have standing, but this one does. When we already know. I mean, it's all a fugazi. And Biden does have the ability to go back and try this again under a different authority. This was the authority that a lot of people on the left were advocating for, the one that would be broader, and why he chose not to do it, the Higher Education Act.
This is why, quote Shook ones, there's no such things as halfway crooks.
Yeah.
You got to do it. And like, that's the lesson here. And Biden needs to act in some fashion. There's no, look, I'm not surprised at this. This is what happens when you have a Supreme Court. They exist to bat shit like this down. The question is, like, what is Joe Biden going to do about it? Is he going to say, oh, ho, ho, I'm vote harder? Because I'm not here for that.
Well, we'll play what he had to say yesterday in the wake of the affirmative action decision, but it's still clearly very relevant today in a second. But yeah, I mean, and it's as insufficient as you'd imagine. But he should be looking into an alternative route here using the Higher Education Act signed in 1965, which essentially gives the Department of Education broad authority over everything involving grants, federal student loans. 90% of student loans in this country around held by the federal government. And that authority is much more enshrined. But, you know, even John Roberts in his majority opinion was trying to preemptively beat that back. It doesn't mean Biden shouldn't try, especially because this was already sent out to people. I mean, like, this is a central campaign promise just from an electoral perspective for Biden. Let's go. Start it again. I mean, he should at least make all of it 0% interest going forward.
All they accomplished is getting people's information so they can start payments up. That's all they accomplished with that little thing. And it's not acceptable.
No. And on the other decision from earlier in the day, discrimination against same-sex couples, let's be clear, this was another case in which, after oral arguments happened, it found out that the plaintiffs just were making up the harm that is the undergirding of their entire case in front of the court. It was fabricated, the New Republic found. I want to give Melissa Gira Grant a ton of credit for finding this and speaking to the person on the filing to make this clear. But that in this case, 303 Creative LLC versus Elenis, it was about a Colorado law that banned public serving businesses from discriminating against LGBTQ people. And that also included saying, like, I'm not going to serve X, Y, and Z, publicly saying something like that in preemptively, essentially. But the plaintiff, this woman named Lori Smith, who's really just backed by the Alliance Defending Freedom, which is the major right-wing Christian group funding the anti-trans bills throughout the country, the anti-abortion bills throughout the country. I mean, they're the big boogeyman of, I would say, the 2020s, right? Like, we were talking about the Koch brothers, all of the 2010s, and this is, I think, one of the next frontiers in right-wing efforts to beat back progress. But it was essentially a lie by the Alliance Defending Freedom, her legal team, and the plaintiff. And this is what the New Republic found yesterday before this case was handed down. Long before the Supreme Court took up one of the last remaining cases it will decide this session, the 303 Creative vs. Elenis case concerning a Colorado web designer named Lori Smith, who refuses to make websites for same-sex weddings and seeks an exemption from anti-discrimination laws, there was a couple named Stuart and Mike. According to court filings from the plaintiff, Stuart contacted Smith in September 2016 about his wedding to Mike early next year. He wrote that they would love some design work done for our invites, place names, etc. We might also stretch to a website. Stuart included his phone number, email address, and the URL of his own website. He was a designer too, the site showed. This week, I decided to call Stuart and ask about his inquiry. No one had called him, essentially, the reporter discusses. It was the first time that he had ever heard of it, apparently. Yes, that was his name, phone number, email address, and website on the inquiry form, but he never sent this form, he said. And at the time it was sent, he was married to a woman. The quote is from him, "If someone pulled my information as some kind of supporting information or documentation, somebody's falsified that," Stuart explained. Stuart's last name was not included in the filing, so we will be referring to him by his first name throughout the story. "I wouldn't want anybody to make a wedding website," he continued, sounding a bit puzzled but good-natured about the whole thing. "I'm married. I have a child. I'm not really sure where that came from. But somebody's using false information in a Supreme Court filing document." When Smith and her attorneys, the Christian right group Alliance Defending Freedom, or ADF, brought this case for the first time, it was to the United States District Court in Colorado in 2016, and they lost. Smith and ADF filed the case on September 20th of that year, asking the court to enjoin the state anti-discrimination law so that Smith could begin offering her wedding website design services to straight couples only. Up to this point, Smith had never designed any wedding website. In fact, her website 6 months prior to the lawsuit being filed in 2016 does not include any of the Christian messaging that it did shortly afterward and today, archived versions of the site show. The initial lawsuit did not mention the Stuart inquiry, which was submitted to Smith's website on September 21st, according to the date stamp shown in later court filings, indicating that she received it the day after the suit was originally filed. So basically, she's a patsy. I don't know what she's benefiting from with this. I'm not a conspiracy theorist, but look.
This is all simulated bullshit.
She could totally be making some money off of this. Let's just be real.
Yeah.
I know it's simulated, but like, I want to lay that out because these are two major cases. This latter one opening up much broader implications for cases that the ADF is going to keep funding. They'll find their next patsy. They'll find their next person who's going to be the face of their anti-gay hatred, anti-trans hatred. This kind of stuff is signaling to them, keep it coming. Keep it coming. We're going to do more of this kind of stuff. And unfortunately, this is the way that our president has responded response is too active of a verb. Responding is too active of a term to describe what he's doing here. This is what he had to say yesterday in the wake of the affirmative action decision.
Do you worry that without court reform, this conservative majority is too young and too conservative, that they might do too much harm?
Well, I think they may do too much harm, but I think if we start the process of trying to expand the court, we're going to politicize it maybe forever in a way that is not healthy.
That you can't get back.
That you can't get back. And I think, look, maybe it's just the optimist in me. I think that some of the court are beginning to realize their legitimacy is being questioned in ways that hadn't been questioned in the past. And I think there's a concern on some, maybe even the Chief Justice, that maybe we better.
Well, in the independent legislature's decision, it looks like maybe Roberts had that in mind.
I don't know that.
I don't either. But you could, the optimist could hope so, right?
Hope so.
We didn't elect you to be an optimist, you old effer. Like, this is not about spending the court. Sorry, that's 2009. That we need to stop talking about expanding this slaver institution. Here's a little thing from Second Rate Democracy. I was looking up judicial review. Matt Karp wrote a really good thing in Jacobin how Abraham Lincoln dealt with the Supreme Court. But this is an interesting section from a website, Second Rate Democracy, which I've never heard of, but I enjoy the name of. Many Americans would be surprised to learn that some other leading democracies do not consider judicial review as a necessary part of a democratic system and do not give that power to their courts. In Great Britain, for example, their highest court does not have the power of judicial review. Its job is to rule on decisions made by the lower courts, not to rule on whether laws passed by Parliament are valid. New Zealand has no judicial review, and the Constitution of the Netherlands explicitly forbids it. Finland, Luxembourg, Norway, Sweden, and Switzerland managed to get along without it as well. In these countries, it is thought, here's a crazy thought, it is thought that the legislature, the elected representative of the people, is the most appropriate arbiter of constitutional issues. It is seen as undemocratic for the views of unelected justices to override the views of legislators who represent the will of the people. And anybody who is not on board with that, anybody who has this naive, let's just expand it, let's just add a few more. I'm sorry, that's not even it.
More high priests? I mean, that's
exactly
what we need, I guess. More high priests who have lifetime appointments, are completely unelected, and they have the capacity to strike down legislation from, in the case of Colorado, this was their own anti-discrimination law. And they're essentially saying, nah.
Because it's there for the purpose it's serving. It's not there to actually to pull these threads of what's legally going on and all the nuance. It's there to control you.
But I'm walking even my statement there back, really, because the broader problem is their ability for judicial review on the federal level. It's the federal level. And another person I'll plug is Jeet Heer had a great piece in The Nation about how it is insufficient to talk about these kinds of tweaks and reforms. We need to disempower the courts. That was his ultimate thesis in his piece. And essentially, we need to end, as Matt was saying, the ability, at the very least, severely restrict judicial review over federal legislation. Bottom line. And Biden's response there, has anything aged worse in a 24-hour period? I'm sure he would honestly have the same answer anyway today. Yeah. Because he's not able to meet this moment.
No, he's not. There's no new tricks.
In some ways, Biden has been better than I anticipated, but in terms of these existential threats to democracy, and that's what this is. The court is acting as an anti-democratic institution. It should not have the ability to override these kinds of things.
Yeah.
And he's unable to meet it structurally in any way.
Somebody in the chat, does Matt have the slightest plan to accomplish any of this, or are we going to keep having dorm room conversations? The dorm room conversations is this idle expand the court bullshit.
Yeah. Yep.
I'm going to put it in the exact same place we were last time.
Get serious, person in the chat.
We need to put it more pointedly, you should not, I think, voting, the question on who you should vote for, I think typically vote for Democrats because labor's behind them. As far as giving money, unless they are, maybe Cory Bush is going to be forthright about this member of the squad, but you should not be giving any money to somebody who has even an expand the court initiative. This is about getting rid of judicial review. And like we've been propagandized, like from the I'm Just a Bill on Capitol Hill, the 3 co-equal branches. There should not be a third co-equal branch of unelected, monks in robes saying don't do that.
Yeah, exactly. That's exactly. And I just want to say, I'm going back through Jeet's piece here, that this was actually a agenda item in the early half of the 20th century of progressives and leftists that was abandoned because they thought the Warren Court was on their side ideologically.
But the Warren Court would never got there if that didn't exist.
But look how that turned out, though, right? Look how that turned out. Of course it was not going to be static. And then the right had this incredibly well-orchestrated, well-funded campaign on the side of the judiciary, and they got what they wanted. And the fact that there's so much money on their side makes reform way more difficult now, since they've built up these institutions, than it would have been back in the day. And so Biden has to understand that history. I have no faith that he does understand that history, and I have no faith. I'm sorry, we'll end here in a sec, but I have no faith that he's honestly even ideologically committed to student debt cancellation, because he still did the bare minimum that he could have done.
Exactly.
And was like dragged kicking and screaming, it seemed like, to do it. And we had to undergo this like legal review process about if he could even do it.
Yeah. And you know what? They might not care about doing it so much now, because people are going to vote because of Roe versus Wade.
Electoralism, I guess.